And I actually have some exclusive reporting on the James Comey case that I'm going to use to clarify the record that's been misreported in a second. But let's just set it up for the audience what we're dealing with here. So the acting U.S. attorney for the Eastern District of Virginia, Lindsay Halligan, was appointed by this DOJ, and she indicted Letitia James and also James Comey. And James Comey is accused of lying to Congress about when he purported to say, I never authorized anyone to leak on the matters of the Trump investigation or the investigation into Hillary Clinton's email use. He said that under oath, and the theory is you did authorize somebody to leak. It was your good pal, Daniel Richman, who you brought on at the FBI as a special governmental employee, and you absolutely did use him to leak about in particular, the Hillary investigation. So that's what the case is about. Comey's trying to get out of it any way possible. And he's not only got an argument that substantively he didn't do the things that they're arguing he did. He's got an argument that A, she wasn't properly appointed, and that's going to be argued and heard by a different judge. But B, he's now challenging the actual four corners of the indictment as inappropriate and like not properly styled, not properly brought before the grand jury. And that hearing got very heated on Wednesday. I'm going to play you a little from CNN's Caitlin Pollance, who is their legal correspondent, I think, on the drama, she said, when she says it was revealed. Because just as a background for the listening audience, originally there were 3 counts that Lindsay Halligan proposed against James Comey. The grand jury was ready to return an indictment on 2 of the 3, but they weren't convinced on the 3rd. And so she struck the 3rd and went back to the grand jury, and they approved those 2 and said, yeah, let's go. Now there's a question about whether she did in fact go back to the grand jury and get them to bless what would be the final indictment with just the 2 counts that we know the grand jury did like and did believe in. And the judge, this wasn't even brought up by Comey's lawyer. This was the judge who thought there were like missing minutes in the like there wasn't enough time for you to, after they struck the 1 count, for you to redraft the indictment, get back with a clean indictment with the 2 counts. There's some funny business going on. Did this grand jury actually bless it or didn't they? And here is CNN's Caitlin Pollance describing the in-scene courtroom experience yesterday, SOT 30.
I've been in a lot of these hearings in politically charged cases over the years. This was gobsmacking. It was absolute silence. I've said before in this case that there have been moments where people gasped, but this was, you could see the entire room shift. And from then on, this was the only thing that was mattering in that case. This is the only thing that the judge and that others were talking about.
And I'll give you one more. This is Trump 1.0 White House lawyer Ty Cobb and his reaction to the news yesterday, SOT 31.
So that hasn't been dismissed yet or thrown out or the nullity been recognized. I do think if the ruling is that there is no indictment, there's no indictment to dismiss. Only if the indictment is dismissed would the 6-month rule for representation come into play. So what happened today is very significant in that regard legally. But yes, Comey has, the misconduct issues, the miscarriage of justice issues, the denial of due process issues, the vindictiveness issues. This case is dead. This case is never going to get to trial. And Comey will, never be held accountable as the government has desired and as the president ordered Bondi to see to.
Okay. And here's the last point I'll make before we get into it. I have exclusive reporting here on what actually happened in court yesterday. The entire grand jury, I've been reliably informed by a source who's in a position to know, did see the final indictment with just the 2 counts. They did see it, review it, and approve it. And I'm told that there is a transcript of that proceeding which will prove exactly that. The magistrate judge then confirmed with the foreperson on the record in open court at the time they returned the true bill that everyone on the grand jury had voted on that indictment that has 2 counts. So I believe that this entire issue will be cured as soon as these magistrate judges, the magistrate judge and the judge above him, the district court judge, get a look at what actually happened with the judge and the grand jury overseeing these two counts. I think it's all going to be cured. I think my belief is this is a misunderstanding. But let's proceed as though it isn't a misunderstanding and that she didn't cross her T's and dot her I's, and she just had the grand jury vote on I'm picturing like a piece of paper that has 3 counts. They crossed out 1 and just kind of let the 2 the jury had earlier approved when it was 2 of 3 stand. Is it an okay, true bill? Does the prosecutor have a problem on her hand? We'll do ladies first. Ashley?
I think it's a fine one. I think the indictment's fine, and I think it would stand. Doesn't mean I wouldn't argue for dismissal as a defense lawyer, but I think it's one of those situations where you could put an indictment on a napkin. I mean, if you wanted to write it out, you could. There's no rule that says it has to be in a certain order or look a certain way. So as long as that language is the exact same, and it sounds like it is, as long as the language is the exact same, if they went and they made what we would call a Scrivener's change, that's just a change, changing the heading, changing the title, changing the numbers, I think it's completely fine. And, it's interesting because in the Trump indictment in Georgia, they actually had the numbers changed. So we had this same issue and it never made it to court. The numbers were actually changed when they scanned the indictment.
What do you mean the numbers changed?
Yeah, it was one of those racketeering indictments. And so they had different numbers for predicate acts. And the numbers actually, when they scanned it, we had this whole controversy. It never really came to light, but we had it internally about the e-filing system in the court system. When they scanned the indictment that was actually returned, it changed the page numbering and the actual numbering. And we were trying to figure out, was that in front of the grand jury? Was it not? And everybody said, oh, well, it's just a Scrivener's error. And I think this is the exact same thing. It does, as long as it doesn't change the language of the indictment, it's going to stand.
What do you guys make, Mark and Phil, of the fact that the judge raised this? This wasn't even raised by defense counsel. And the same judge then asked the defense counsel, do you think Lindsay Halligan is just Trump's puppet? And even the defense lawyer was like, no, I'm not going to go that far. I mean, to me, it just shows this judge is not a fan of this prosecutor and maybe this prosecution, but it doesn't bode well for Team Trump in that courtroom that he's raising these things himself and then calling her names and getting the defense attorney to trying to get the defense attorney to sign on to those names. I'll start with you, Phil.
All right. So look, this is really much ado about nothing. If you can't win on the facts, you attack the law. If you can't win on the law, you attack the prosecutor. And in this case, Halligan and her team are having to deal with not only the defense raising these issues, which is understandable, but she's also having to deal with a judge who, in my opinion, has abandoned his role as a neutral arbiter, okay, and has basically thrown in with the defense team in attacking the prosecutor. This is a non-issue for all the reasons that Ashley set out, but I would also add that Rule 6F of the Federal Rules of Criminal Procedure say that as long as a quorum of the total grand jury has approved the charges, it can be returned in open court by the foreperson, okay? So this was just an administrative thing. The entirety of the grand jury voted yes, there is probable cause as to 2 of those charges, and those are the ones that were filed. It's absolutely not an issue whatsoever. The court reporter even had an email that confirmed that that all this is the case, and that the grand jury foreperson's open court statements support that this is exactly how it went down. This document that was filed in the court, these 2 charges were reviewed by the grand jury. They gave it a thumbs up, a true bill. That's it. If this judge decides he's going to throw it out or do something else with it, then obviously the government will have the right to appeal, because that would be absolutely grounds for reversal. This is absolutely astonishing that federal judges are abandoning their judicial role in this way.
And it would be, just to be clear, Mark Eiglarsh, devastating to the government's case if these judges, the magistrate judge and the district judge above him, find this to be fatal because the statute of limitations has run on Comey. So if they can actually convince this judge that there was an irregularity that kills the existing indictment, Comey's off. He's off scot-free.
That's correct. So my analysis hinges upon what the facts are, and we're gonna play hypothetical. And the original story was it was just the grand poobah of the grand jury and one other grand juror who approved the final version. Let's assume that those are the facts for one moment. I also don't take exception to a judge stepping in, because my feeling is a judge is always there to ensure that due process is happening. And put aside Comey for a second. Let's say this is one of your loved ones in federal court, and you learned, not these particular facts, but you learned somehow the whole grand jury didn't approve the final indictment, that it was just the head guy and someone else with him who approved that final document. You're doggone right you'd have me argue that there's a defect there and something
Can I just
needs to
ask
be
you that,
done.
Mark?
Sure.
Sorry to interrupt you. Can I just ask you?
Sure.
Totally fair case, and I agree with you. The judge has the obligation to make sure the proceedings are fair. But would it also be the case, even if the grand jury, no one's disputing that the grand jury approved these other two counts. The full
Right.
grand jury approved these other two counts.
Right.
They didn't approve the third. They crossed off the third. How does that render the original two as required for another vote, as like that they needed another vote? They already approved those two counts.
Yes, and it might not, right? Just so we're clear, legally, a court may find that it's totally okay. But the argument will be that the law requires the entire body of the grand jury to approve whatever's ultimately there for prosecution. And if you cut corners because you want to get Comey, be prepared to have the law changed so they can cut corners on someone you really love and care about.
And again, just to remind the listening audience, my exclusive reporting today is that they did not cut corners. They actually did have the entire grand jury approve the
No
new
issue.
two-count indictment, and that was all on the record with the magistrate judge, that the magistrate judge confirmed with the foreperson on the record in open court that everyone on the grand jury voted on the indictment that has two counts, which does kind of, I don't know whether it's the same magistrate judge that they're in front of right now. I don't think it is. I think it's a different magistrate judge that handled the grand jury proceedings. But I mean, that does sort of like make you wonder if that's there and the magistrate judge, let's say she can just show the current magistrate judge and the district court judge, Ashley, here's the transcript that shows the earlier magistrate judge who dealt with the grand juror asking that the foreperson, did the entire grand jury approve this? And that foreperson saying, yes, they did, that the entire grand jury approved of the indictment that has just the two counts. That should be the end of this nonsense, no?
It should totally be the end of this nonsense. And because there's other judges bringing it up, they're trying to undermine the indictment. They're trying to undermine the entire process. And that gets out. You know, the world is watching. The world is listening. And so any juror, potential juror on this case is going to know about that. They're going to have heard that. It's all over the news. So it's really prejudicial when a judge is trying to intervene in such a manner and really put their thumb on the scales of justice.
My friend just lost her ring. She went to replace it. She realized it was a gold ring. The price of it has gone up like 25% since she bought the ring a year ago. That's because gold is on the march upward. And it is the one time of year that Birch Gold Group gives away free gold with every qualifying purchase. That's right, for Black Friday, when you convert an existing IRA or 401k into a tax-sheltered IRA in gold, Birch Gold will send free gold to your home for every $20,000 purchased. Gold started this year around $2,600 an ounce. By October, it was over $4,000 an ounce. Why? Global uncertainty. 2025 has been defined by trade wars, central banks are pulling from the US dollar as the global reserve currency, and military tension continues to build. Gold thrives in times of uncertainty, and if you are looking to diversify your savings, Birch Gold can help you. Plus, now through November 30th, get free gold, I say, with a qualifying purchase. Just text MK to the number 989898 to claim your eligibility and for a free info kit on gold. But your opportunity for free gold with purchase will end on November 30th, so don't wait. Text MK to the number 989898 for full details. Message and data rates may apply. Thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.